What is Title VII of the Civil Rights Act? When workplace discrimination strikes Miami workers, Title VII of the Civil Rights Act of 1964 stands as their most powerful federal protection. This landmark federal law prohibits workplace discrimination based on race, color, religion, sex, and national origin across all employment decisions. Title VII covers hiring, firing, promotions, pay, and other terms, conditions, or privileges of employment for workers nationwide. Congress enacted this law as part of the Civil Rights Act of 1964 to address systemic discrimination in the American workplace. An employer cannot use a protected characteristic as a reason to refuse to hire you, fire you, deny a promotion, reduce your pay, or change your working conditions. The law also prohibits retaliation, meaning your employer cannot punish you for reporting discrimination or participating in a discrimination investigation. Title VII applies to employers with 15 or more employees on each working day in 20 or more calendar weeks of the current or preceding year. This includes private businesses, state and local governments, employment agencies, and labor organizations throughout South Florida. The law protects 5 specific classes: race, color, religion, sex, and national origin in all workplace decisions. Race and color discrimination includes treating an employee differently because of their racial identity, skin color, or associated characteristics such as hair texture. National origin discrimination covers bias based on a worker's country of origin, ethnicity, accent, or perceived ancestry. Sex discrimination under Title VII extends beyond just treating men and women differently to include pregnancy discrimination, sexual harassment, and gender stereotyping. The U.S. Supreme Court expanded Title VII's reach in Bostock v. Clayton County in 2020, ruling that sexual orientation and gender identity discrimination constitutes sex discrimination. This ruling means Miami workers who are gay, lesbian, bisexual, or transgender have the same federal protections against workplace discrimination as other employees. For religious discrimination, Title VII requires employers to reasonably accommodate an employee's sincerely held religious beliefs, practices, and observances. While Florida is an at-will employment state, Title VII creates a critical exception that overrides this rule when termination is based on protected characteristics. The U.S. Equal Employment Opportunity Commission enforces Title VII at the federal level, and workers generally must file a charge with the EEOC before filing a lawsuit. A wrongful termination claim under Title VII requires a connection between your protected class and the decision to fire you through direct or circumstantial evidence. If you believe you've experienced workplace discrimination, contact BT Law Group, PLLC at 305-507-8506, located at 3050 Biscayne Boulevard, STE 205, Miami, Florida 33137, to schedule your consultation today.